Barb, are you ready to start the Zoom? Or the video?
You
Or
are live,
Danielle?
Mr. Chairman.
Okay, we're live. Want to call the meeting to order. Chairman Zwanitzer is unable to be here today, so you lucky people get me again. Barb, would you take the roll, please?
I will. Representative Blackburn. Representative Clausen.
Here.
Representative Clifford.
Here.
Representative Duncan.
Here.
Vice Chairman Air.
Here.
Representative Hunt. Representative McGuire. Representative Roscoe.
Here.
Chairman Zwanitzer. Thank you.
Thank you. Our first bill for our consideration today is House Bill number 16, Improvement in Service District Limitations. I believe Representative Stiff is going to present the bill for us.
Mr. Vice Chairman, members of the committee, thank you very much. This is a committee bill, of course. It was loosely based on an individual bill that I had brought last year. Just walking through the core of the bill begins on the top of page 2. And I'll just go ahead and read this first sentence. It's a long sentence, but I think it's really the core idea. It provides that except as otherwise provided in this section, a district shall not impose any fee, charge, mill levy, tax, or other assessment, or adopt a budget that results in imposition of the same, that when aggregated would create a payment burden on landowners within the district that exceeds any limit stated in the district's original petition for formation on the maximum fee, charge, mill levy, tax, or other assessment that may be imposed by the district. So we have lots of special districts. All special districts, except for service and improvement districts, have a statutory maximum mill levy they are allowed to impose. So cemetery districts are 3 mills, flood control is 12 mills, and so on. But when the service and improvement district was created in 1977 or thereabouts, no maximum was put in statute. And there may be good policy reasons for that, because it's possible that a district might want to do something frankly very expensive. Maybe they would want to build a bridge or something and have a high mill levy or its equivalent. Because there's no statutory cap, when a developer is trying, or anyone is trying to form a district, it can and does happen that the developer or the people promoting the district will promise a cap in the petition. They say, landowner, would you please sign this petition to form a district? And as an incentive to do so, the petition itself might say the maximum mill levy is 8 mills. So the problem that we have, and that this bill is intended to solve, in my view, is that we have at least one district court in the state that has held that when there is such a mill levy cap put in the original petition for formation, that is not enforceable, that it doesn't mean anything. And that seems counterintuitive, because the landowners who signed up to create this district probably thought that it did mean something, right? You know, someone promises you your taxes won't be above 8 mills. You buy land in reliance upon that promise, and then suddenly the court tells you it doesn't mean anything. So what this bill says is that this, if there is a cap in the original petition, that it's enforceable. And then I think this bill is very flexible, because as the committee worked through it over the interim, on page 3, I think lines 5 through 8, it says that any such cap may be eliminated, reduced, or increased if approved by a majority of the qualified voters of the district by mail ballot election pursuant to Wyoming Statute 22-29-116, or concurrently with any other district election. So I think this bill provides flexibility so that if, for example, a district had a mill levy cap of say 8 mills or 12 mills, if circumstances changed and suddenly the district decided, well, we don't have county roads, but we want to have asphalt paved roads, which would be very expensive. If a majority of the landowners agreed to that, they could say, well, we're going to raise the cap from 8 mills to 16 mills or 24 mills or some other amount. The section C puts a limitation. This is on page 3, lines 10 through 16. This tells the landowners that if they don't like an increase that busts above the cap that was in the original petition, that the landowner can't sit on his rights. He or she has to file suit within 120 days. And if you don't, you lose your right to object to it. And then finally, subsection D, lines 18 through 20, says that whatever cap that you've got in your petition and the limitations imposed by this bill on busting through that cap do not apply if you decided to bond. So for example, if you had an 8 mil cap in your district, but you wanted to build a bridge or something expensive in your district, or a bridge washes out over a stream and you want to create a new pump system, but instead of taxing yourselves and paying as you go, the district wanted to issue bonds that the bonds would not be subject to the cap. So with that, I think that highlights one feature of page 2. You'll notice this language is a bit clunky, right? Because it doesn't just say mill levy. Our statutes talk about mill levy caps. You'll notice that on page 2, lines 1 through 5, in this first sentence I read through, that you've got fees, charges, mill levies, taxes, other assessment, or adopt a budget that results in imposition of the same. The reason that adopt a budget language is in there is because the legislature about 12 years or so ago began a series of amendments to change how special districts do their budgets. So right now, instead of assessing a mill levy per se, what the special districts do is they have their board approve a budget. That budget gets submitted to the county commissioners. The county commissioners approve it. And when they approve it for special service and improvement districts, the way it shows up on your tax bill is not as a mill levy, but as a dollar amount. So this bill is broad enough to capture that. So thank you for your patience, and I would stand for any questions.
Any questions for Representative Stiff? Representative Roscoe.
Thank you, Mr. Vice Chairman. Representative Stiff, I was just trying to figure out, does the same, the voting procedure where you need the majority of qualified voters, that same, would that apply to lowering their mill rate or adjusting their rates at all? Thank you, Mr. Chairman.
Representative Stiff.
Mr. Vice Chairman, Representative Roscoe, that's correct as drafted right now on page 3, line 5. The language says may be eliminated, reduced, or increased. So it appears to say that if you had a particularly virulent anti-tax movement in your district and they wanted to take it from 8 to 0, this language would allow them to do that. And the district would wither away, I assume. So if you want to amend that to put some curbs on that, you might find that appropriate as well, but a majority of voters could cut it back. Again, in terms of when I brought an individual bill, that wasn't the sort of problem I was contemplating, but theoretically that could happen.
Any other questions?
Thank you, Mr. Vice Chair. Just to follow up, it seems to me like what we're changing here, and I'll bring this up a little later, is that certain districts across the state have not been able to ever get a majority of qualified voters. And the way they operate now is on the majority of voters in this district, qualified voters in the district that cast votes, just like we as representatives are elected and the governor is elected. And so some of these districts have never received 50% of the qualified voters. That's just my concern. Thank you, Mr. Chairman.
You have a response to that, Representative Smith?
Mr. Vice Chairman, Representative Roscoe, I think that certainly is a consideration, especially if you have a district that's formed of landowners who perhaps have mostly vacation homes, for example. And so they may reside most of the time far, far away and may not be paying attention to their mail or particularly care. And so they may never vote. If the committee deemed it appropriate, one amendment you could make to this would be to change that language and to say, instead of a majority of the qualified voters, you could say a majority of the votes cast. And that's I would regard that as a reasonable policy choice. That's up to you to decide. I don't really have a strong opinion one way or the other about that.
Thank you. Any other questions for Representative Stiff? Representative?
Thank you, Vice Chairman. Representative Stipp, who or how does a district get established?
Mr. Vice Chairman, Representative Clifford, that's a great question. And I'm going to give you a somewhat unsatisfactory answer because it's changed over time. It used to be that you had to have petitions signed by 60% of the landowners representing, I believe, at least a majority of the land or something like that. And then it got amended, but I think there's still a double requirement that it has to be a number. You have to get over a certain threshold by number of landowners, but you also have to have, there's an acreage requirement, I believe, that's still in statute. And I apologize that there was one rule adopted in the 1970s and then it got amended in the 1990s, and I've kind of forgotten. But what's typical, what it does require is you have to have a lot of people actually signing petitions saying, yes, we want to do this. And then after you sign the petition, you get a sufficient number of signed petitions that goes to the county clerk. And then the county clerk puts it on to the ballot for the next primary or general election. I believe, for example, a particular district I'm thinking of, at that time, you had to have 60% of the landowners had to be at least over 50% of the property. And I know that this particular election occurred in August. So I know there was a time when you could do it at a primary. I'm not sure if that's still true, but it's a double requirement: landowners, petitions, and then everyone votes.
Any other questions? Representative McGuire?
Thank you, Mr. Vice Chair. And I have two questions. So the first one is, and I did not see it in the definitions, I'm just curious, is the term "to assume," is that defined anywhere in the statutes? Because I could certainly see that there might be some questions as to whether it be degree or the manner of assumption.
And Mr. Vice Chairman, Representative McGuire, I apologize. Can you point me to the page in line that you're looking at?
Well, and let me just. I apologize. I was looking at something different. So strike that question. Thank you, Mr. Vice Chair.
Any other questions for Representative Stiff? I have one. You mentioned that a lot of times these assessments are not based on a mill levy. They're based on a flat fee assessment. Does the county clerk then convert that based on the valuation to a mill levy?
Mr. Vice Chairman, yes, that's my understanding that the new procedure that's now codified and new since about 2009 or so, and then it got amended again in 2013. But it's my understanding that the district, with the board of the improvement district, adopts its budget. When that gets approved, the county assessor then divides that total budget up essentially by the assessed valuation of the parcels and then prorates it. So I think internally, I think the assessor does turn it into a mill levy, but then when it shows up on the tax statement, it's actually a dollar figure, not a mill levy.
But it is based on property value.
It is based upon assessed valuation, correct. So if someone had an unimproved piece of property, they're going to pay less than someone who's got a lot of improvements on their property.
Okay. I might remind everyone here that we're trying to get through two bills. We already got a time crunch, and so want to have all the public testimony we can get, but we'd like to move along as quickly as we could as well. So how many do we have online that are
Mr. Vice Chair, I only see 2 people with their blue hand raised right now, but we have about 15 attendees in the waiting room. Now I see 4 people with their hands raised.
okay? Well, I think we'll maybe to speed things, we'll alternate between in the room here and on deck. If you'd like to get the first person on deck that would like to testify, we'll bring in. Are there any state agencies represented who would like to testify? I don't see any.
Mr. Chairman. Mr. Chairman.
Yes.
um,
Oh, I should ask for legislators that want to give any testimony. Pardon me. Proceed.
Thank you.
Representative
And,
Roscoe.
I'm sorry, I wrote this quite a while ago, and I'm not gonna, it's not as fast as I'd like it to be, but and Representative Clark, Stiff has already clarified some of these things, but anyway, I'm gonna go ahead with it. And what this bill has done for me is forced me to educate myself on special districts. I'd just like to share this to you that the Improvement and Service District Act was created, these special districts in the late 1970s to provide self-services for residents in subdivisions where the county is unable or unwilling to provide services such as fire protection, road maintenance. And to me, this is the epitome of local control. And it doesn't require any state funding or county funding. It's just really good governance, I think. And this bill, House Bill 16, would interfere not only with the ability of these districts across the state to self-govern, but it flies in the face of the Improvements in Service District Act. And I sort of been questioning the intent of this bill as being nothing other than the use of the legislature to settle a disagreement that was in one service district, which had already been settled by the courts. It was court case 8536 in the 9th District Court. So the crux of the matter for me is that this bill.
Representative Roscoe, I may just interrupt you for a second. If you want to give some public testimony or testimony one way there, if we're going to discuss the bill, we'll wait till we move it and then you can give your opinions on
Okay.
that regard.
Thank you, Mr.
That'd
Chairman.
be agreeable.
That's agreeable. I'll hold off.
Okay, thank you. Who in the room would we have wanting to testify on House Bill 16? We got somebody in the waiting room ready? Well, I know, but I'm gonna I can't see the name there. Would you?
Mr.
please-
Vice Chairman, we have Brett Moline here.
Okay, Brett Moline, please proceed.
Mr. Chairman, committee, thank you. Brett Moline, Wyoming Farm Bureau Federation, supporting this bill. I do appreciate that it goes to a vote of the people, but I think putting the boundaries on any type of government is a good idea. I'm pretty surprised that this type of district doesn't have the restrictions that others do. And to a comment that Representative Roscoe made, I do appreciate his thoughts on that it's a majority of the votes cast rather than getting a majority of the property owners, majority of those people. I think the world's run by those that show up. If you want to show up and vote, that's what you need to do and get your vote heard. With that, Mr. Chairman, sitting in support of this bill, I would sit for any questions.
Any questions of Mr. Moline? Seeing none. Mr. Winnie, are you prepared to please come up and introduce yourself? Give us your testimony.
Yes, sir, Mr. Vice Chairman, Bill Winnie, Sublette County. Support the bill. As I see it, it's about limited government, local control, if you will. Changes can be made, as Mr. Moline just mentioned, by a balloted vote. And There was a question about how they did the vote. 60% of the people are property owners and 60% of the property values was the way it was written. At any rate, as regards the assessment process, I happened to talk to the assessor in my county, and yeah, they take the budget, divide it by the property values, effectively create a mill levy, and then multiply that back out, and what appears on your tax bill is a dollar amount, but it's effectively a mill levy. Subject to your questions, thank you very much. I support the bill.
Any questions for Mr. Winnie? Seeing none. Who have we got next on the screen? Danielle,
Mr. Vice Chairman, we have Melissa Turley.
Melissa Turley. Introduce yourself and please proceed.
Thank you, Mr. Vice Chairman and members of the committee. I am Melissa Turley, the Executive Director of the Teton Village Association Improvement and Service District. And I am making comment in opposition to this bill. As you heard, to form an improvement and service district, it requires a petition as well as an election. To increase the assessment level requires an assessment. To levy a special, or it requires an election. To levy a special assessment requires an election. So there are many opportunities for property owners within the district to weigh in. And I appreciate the comments of Representative Roscoe that improvement and service districts are the closest government to the people. We are formed to be able to provide services within our districts, again, that cannot be provided by the local county, and the members of the district choose to be members of the district and therefore to fund the necessary services and improvements. Just one last comment. If you do move this bill forward, I would speak in support of the amendment that has been suggested to change the threshold to a majority of votes cast. With that, I'll stand for any questions. Thank you.
Any questions for Ms. Turley? Thank you, Ms. Turley. Appreciate your testimony here today. Who is next, Danielle?
Next, we have Ms. Molly Nemitz. I apologize.
Molly Nemitz. Ms. Nemitz, would you get in? Are you able to bring her in, Danielle? There she is. Molly, Ms. Nemitz, would you please proceed?
Yes, hello. Thank you, Mr. Vice Chairman and members of the committee. My name is Molly Nemitz, and I'm a resident of Sublette County. My husband and I have owned property, now a part of a large improvement and service district, since 1980. I'm somewhat familiar with the statutes and the history and the procedures of improvement and service districts because my husband has been on the board, and I also was involved in the late 70s and early 80s with the drafting of the improvement and service district legislation when I was a staff member at the LSO. So I have a number of concerns about House Bill 16, but I will focus on 3 issues. The first one hasn't really been discussed, but the one that concerns me the most is that House Bill 16 undermines the authority of the Board of County Commissioners and the voters to establish an improvement and service district as granted specifically by both the Improvement and Service District Act and the Special Districts Election Act. The filing of the petition with the county is merely the first step in forming the district. Petitions often originate with developers who are trying to transfer the costs of services and improvements to the property owners when a county may be unwilling or unable to provide those services. And the developer wants to maintain a level of services to continue to attract sales, but relieve himself of the responsibility. Therefore, a petitioner wanting to entice landowners to sign might propose anything, such as the roads are going to be paved, we're going to have fences made out of gold, and we're going to have a really low mill levy. But when the signatures of when the petitioner can obtain 60% of the landowners owning 60% of the land, so of the acreage, are obtained on a formation petition, that petition is submitted to the county, and then the Board of County Commissioners must hold a public hearing. Under Wyoming Statute 22-29-109, after that public hearing, the board may either reject or approve the petition as presented or modified. That language is in the statute. And by resolution, then they submit the question of formation to the voters of the district for ratification. And under the statute 22-29-111 subsection C, the formation may be approved by a majority of district voters casting ballots. So I would be in support strongly of that amendment. If the Board of County Commissioners modify the terms of the petition and the petition signatories don't like it or don't agree with it, they can simply vote no on the formation. But it is clearly the Board of County Commissioners, not the petitioner, that is granted the authority to establish the district through resolution. In the recent court case that has been discussed, the court clearly stated that the petition for formation is not its charter, but the district is established by county resolution and then ratified and organized by the subsequent formation election. In addition, only the county resolution, not the petition for formation, establishing the district is a legal document filed in the county land records, and therefore it is the county resolution that provides notice to future taxpayers. The next issue I want to touch on is about why the Improvement in Service District Act doesn't impose mill levy caps like in other districts. There are compelling public policy reasons not to restrict arbitrarily those district budgets based on a request of a non-binding, non-ratified petition for formation. This is because improvements like roads aren't static costs. Aging infrastructure, inflation, fires, floods, plus expanded use and changing expectations can dramatically alter a district's annual maintenance budget. Property assessments, which are based strictly upon mill levies, fluctuate, and a downturn could leave a district with reduced taxation. There's an example here in Sublette County. The Roosevelt fire destroyed 55 of our 150 homes and about 3/4 of the 6,000 district acres. And significantly impacted the district's tax base just when we needed the revenue the most. And as a district can experience, unexpected legal expenses can drain more than a district's entire year's maintenance budget, even when the court decides 100% in the district's favor. House Bill 16 actually encourages litigation, and it does not protect taxpayers, but leaves them exposed to potentially unjustified and unexpected legal costs. And you can't bond for legal expenses. Finally, the last issue is a direct conflict with the provisions of the Improvement in Service District Act authorizing special assessment. That's a procedure where a district can assess and provide services to certain parts of a district benefited more by a desired service or improvement than other parts. House Bill 16 would negate this procedure altogether because of the aggregation requirement. No one taxpayer could be assessed, even if they wanted to be, more than the mill levy requests found in the non-binding, non-ratified petition of formation, unless overall budgets were drastically reduced. Special assessments are an effective tool in the toolbox to transfer costs to the appropriate district taxpayer and allows flexibility, especially in a large district like the one I live in. They should not be negated by the provision of this bill. So thanks for your time. Last year, this bill was described as a simple bill, but it's not a simple bill. It could have significant impacts on improvement in service district residents across the state. And imagine the impact on counties if it caused districts to dissolve based on insolvency. I would totally support an amendment to add to the voting requirement of casting ballots, but I would also strongly urge you to substitute all references for petition, substitute the county resolution establishing the district for the language petition for formation. Thank you, and if anybody has any questions. I'm available.
Thank you, Ms. Nemitz. Appreciate your testimony here today. Any questions for Ms. Nemitz? Representative McGuire.
Thank you, Mr. Vice Chairman. And I appreciate your comments very much. I've got a couple of teenagers that I would love to have you be able to tell them some things because you covered everything. So thank you very much. But my question is, since this is all about the imposition of fees, is there a specific situation floating around out there that where there has been an unfair imposition of fees that you're aware of? Thank you.
I don't, the unfair may be a little hard for me to comment on. I do know that right now in the improvement and service district I live in, there was a small increase for a few years, and now it's back down to the same level it was. And so there's fluctuations. The bottom line is, when I look at my tax bill, I'm paying about the same in 2020 that I did in 2010. So, I can only speak for the district I live in. And to me, this bill is the typical solution looking for a problem.
Thank you. Any other questions? I have one, Ms. Nemitz. I just want to make sure I understand. You said that the omission of a mill levy cap in the founding documents was not just an oversight, it was a conscious decision that you left that mill levy cap out of that petition.
We're talking almost 40 years ago, but that is, I specifically remember working on that because we owned property that was likely going to be part of an Improvement in Service District Act. And so I do know that there was discussion at that point in time not to put a cap on it. But any more specific in that, I can't comment.
Thank you very much. Danielle, anyone else online that wishes to testify on HB 16?
Yes, Mr. Vice Chairman, we have Craig Haslam here.
Okay.
And then we have two following after that. And I believe
Okay,
after
why don't
that,
you bring at least two of them in at the same time and we'll just go through it quickly as we can. Mr. Haslam, would you proceed, please?
Mr. Chairman, members of the committee, thank you for this opportunity to speak with you on House Bill 16. I'm the Fire Chief for Fremont County Fire Protection District, member of the Wyoming Fire Chiefs Association, also president of the Special District Association of the state of Wyoming. This bill is really troublesome. It brings a lot of concerns. Some of those have been expressed. I'll try to get through them, not to cover a bunch of those that have been already mentioned, but to me, this bill is troublesome. I mean, special improvement districts were formed for a reason, and there weren't caps put on those mill levies for a reason, in my opinion, because they're fluctuating all the time. I mean, it should stay at local control, and I know that people have mentioned local control a lot, but I believe that is truly where it needs to remain and stay at. Is those folks need to be able to provide the services that they feel are necessary for themselves. Not allowing them to do that, again, could cause a lot of problems. Those, you look at the Roosevelt fire, as was mentioned earlier, for those people not to make those repairs that they need, it would be very concerning and could put them in a crisis. Also with that, the concern about the majority of landowners in the area having to make that is very troublesome. If we had to wait for the people in the United States to cast votes and every one of them counted, we'd never have any elections done. So that's very troublesome. It should be those who want to participate. I mean, that's kind of the American dream, is to be able to participate, but if you don't want to, you can step back and don't have to do it. And in a lot of the subdivisions in the state of Wyoming, we have a lot of absentee landowners. In Fremont County, where I'm from, I mean, we try to do mitigation work up in some of the subdivisions and stuff. Those who want to participate, and we get a lot of work done, but it's always concerning when you have that one landowner that doesn't want to participate, doesn't do those things. It actually puts those others in jeopardy. And I can see that same thing happening here. It was required that everybody that was a landowner there had to participate, or we had to have 50% of all landowners and not just those who cast votes. And by setting the the cap on these and not leaving it at local control, it could make it almost impossible to get some things done in those subdivisions. And I guess at that point, I'm trying not to cover over some of the things that have already been mentioned. I'll stand for any questions you might have for me.
Thank you, Mr. Haslam. Any questions for Mr. Haslam? Thank you for your testimony. Daniel, would you please bring in our next testifier? And just might remind you folks who are waiting, we do want to get through here as quickly as we can because we have another bill under consideration and we'd like to move along. If you can contribute something new, if you're just repeating testimony, keep it as brief as possible, please. Thank you. Proceed. I can't read the name.
Mr. Vice Chairman, that's Mr. Mark Pepper.
Okay, proceed, Mr. Pepper, please.
Thank you, Mr. Chairman. Mark Pepper, Executive Director of the Wyoming Association of Rural Water Systems. We stand strongly opposed to this bill for most of the items that have been mentioned most eloquently by Ms. Nemitz. Self-rule, the changing environment that improvement and service districts operate under. A lot of those improvement and service districts operate water and or wastewater facilities based on user fees, based on a very challenging and changing environment, both the regulatory and cost in general. And we would stand strongly opposed and really would rather not have this bill go forward as opposed to any amendments. I see it as eradicating self-rule and the will of the voter. And for that, we would be opposed. Thank you, Mr. Chairman.
Thank you, Mr. Pepper. Any questions? Mark Pepper. Seeing none, thank you for your testimony today, sir. Any others, Danielle, that are waiting?
Mr. Vice Chairman, our last testifier online will be Mr. William Conley.
Okay, would you please admit him?
Mr. Vice Chairman, he's in the room, but he does not appear to be starting his video. Oh, there we go.
There we go. Mr. Conley, please give us your testimony. You're muted, sir. I cannot hear you. You're still muted, Mr. Conley. Can you figure out how to unmute your microphone?
Hello. There we go. You got me?
We can hear you. Please proceed.
All right. Thank you, sir. I apologize from waiting. I had it muted and unmuted, and we're back. Just 4 points I'd like to make. Some of them have been covered. To reiterate them, first of all, appreciate the opportunity to speak to the group, to you and the committee. I think one thing they need to point out is that in our specific districts and most of the districts across the country that I've had the pleasure of talking to in Wyoming, their budgetary process is very transparent. It's very much in required collaboration with the county. It all requires public input, and they work very closely with the Wyoming Department of Revenue, who provides oversight to all of our budgets across the state. In our particular district in general, we actually have 2 public meetings to review our budget, unlike some districts do the same thing, where those meetings are actually announced a year in advance and then followed up by email blasts and newspaper postings to remind everybody who is a property owner or an elected voter to please attend the meetings. So these are totally transparent budget meetings, totally open to the committees and the people that live there. And more importantly, all the property owners have input into the budget process, from which we've already had explained that the budget is actually proportioned back to the property owners. Correctly stated before that every home has their value associated with their property that they own. That is then compared to the total value of the property of the district as imposed by the county, and then everyone plays their appropriate proportion share, and that's considered very fair. It's already been mentioned by multiple people about the fact that a lot of the districts have a lot of absentee owners. Our district is not unlike the others. We have 246 properties, about 224 property owners, and we normally get 30 to 40% of our voters who cast a vote. And we have a total mail-in ballot. We mail every property owner a ballot to vote, and they all have the opportunity to vote, but we still only get 30 to 40%. So what I would definitely support casting a ballot if this would go forward. I'm not particularly in favor of the bill, two specific reasons. One is Section C that's already been addressed, the fact that it pretty much opens up everybody who wants to go file a lawsuit can file a lawsuit. And our district, unfortunately, has had to spend an inordinate amount of money. In one case, more than 1 year's full road budget was spent just on legal fees, which is just unheard of when it's normally like $1,200 or $1,300. And then last, the point I'd like to close with is the Wyoming statute 12-115 that allows the districts to impose a special assessment fee to a particular property owner. In our district, we actually put that provision in and had a 3-hour public meeting and input that and people gave us all kinds of input about this. And the reason it was put in was very simply, we had a lot of people that would come in on our public roads and cut in a driveway without a culvert, damage the public road, then cause a drainage problem because they didn't properly drain it. And so we had a meeting with the board members, we discussed this, and we understood the best thing to do is just assess a fee of putting in a new access to one of the public roads and charge it only to that property owner. And we worked with the county engineering firm who actually developed a table based on the size of your home, the number of trucks it would take to build that home, and came up with a fee prorated to that home in a table that was filed and made part of our regulation. So, and again, only assessed to that particular person who does the damage or damages the road, and not the entire community. So with that, again, I would say that I'm not in favor of the bill in general, but definitely if it did move forward, putting the voting of the formation of the district and any actions to be taken should be based on the number of people who cast a vote, not the people that are property owners. And thank you again for the opportunity to speak to all of you today.
Thank you, Mr. Conley. Anyone else in the room to testify on House Bill 16? Seeing none. Committee, what's your pleasure? No one wants to move the bill? Any discussion? You want to, I cut you off before, Representative Roscoe. I guess you can provide some discussion right now.
Thank you, Mr. Vice Chairman. I appreciate that you cut me off, and it was much better said by these other people. So I have nothing else. I guess I don't think that an amendment needs to come forth. I think majority of the qualified voters who vote can vote to address any of their problems. Thank you, Mr. Chairman, Vice Chairman.
All right. Once again, I'll ask, is there any, what's your pleasure, committee? I guess we're not going to move the bill. Okay. I don't know if I've ever had that happen before. Couldn't even get a motion. Next bill for our consideration is House Bill 256. Representative Wharf, you come forward and run us through the bill.
Members of the Corporation Committee, Bob Wharf, I'm pleased to be amongst you guys. This is the first chance I've had to testify before your committee, so I hope you'll be patient and understanding as I work this bill. I bring before you House Bill 256, which is entitled the Wyoming Sovereignty Act. There is what I would propose is a standing committee amendment that is being handed out. As you can see, it's a 15-page bill, and we went through many revisions with LSO's help. And one of those problems we had was there was some errors that we overlooked because we thought we'd fixed them, and they remained in the document once it was printed. So that's what we'll correct with that. But Mr. Chairman, if I can direct you to it, really what this does, this is the accumulation of many hours that was spent by a subcommittee that was put together by the Republican Party. We initially called this the Republic Review, but over time it evolved into becoming what's now called the Wyoming Sovereignty Act. But what it does is it sets up a process whereby we can review federal actions, and we can determine whether or not those actions are in alignment with the enumerated powers that are in the Constitution, or whether or not they are encroaching upon the powers that should be vested in the state. So you'll see on page 1 at the very bottom, it says, we create these 4 sections. And I know we're on a time crunch. I want to go through it as quick as I can, but I want to answer any questions the committee may have. But you'll see the first one is it's section 137-116. It's the right of interested parties to have constitutional determination made. And that just basically says that any person that thinks there's been an unconstitutional federal action as determined by statute 914-103, that they can ask questions of the construction or validity arising under the Constitution, determined by and obtain a declaration of the right status and other legal relations. Talks about any district court in the state has original jurisdiction, determining whether or not to grant declaratory relief for a person under this section. The court may not solely on the decision of the other courts interpreting the United States Constitution, and that they shall rely on the plain meaning and the text of the United States constitutional doctrine as understood by the framers of the Constitution. The next new section is section 914-103, which is compliance with constitutions. That's both the Wyoming and the state constitution, or the U.S. Constitution. You'll see there's the 3 sections. The section C is the one that has some grammatical problems with it. That's addressed by the standing committee, just so the committee can see it. But it basically sets up where we define how we'll be ensuring that we are in compliance with the constitutions of both the U.S. and the state. The next new section that we are adding is 2811-801, which is the appointment of members. And you see what we are proposing is that we establish another joint standing committee on federalism. And the purpose of this is to set up a standing committee that's just like all the other standing committees, such as this committee, and basically have it review the actions that have gone on. It is to be assembled, the speaker and the president, just like they do at the corporations committee. They would determine which members from both the respective houses or chambers would be assigned to that standing committee on federalism. And then the last new section that we create is 28-11802, which is committee powers and duties. And there again, it goes through in detail and it says what this committee shall do. It says the main purpose is going to be to review federal actions that may exceed the enumerated powers in the Constitution, or those that violate the sovereignty of the state or the people, with the purpose of determining if the federal action is unconstitutional. It says the committee shall consider the plain language of the United States Constitution and the original intent making a final declaration of constitutionality. And it says the committee may constitute or may consider the ratifying debates in several states, the understanding of the leading participants in the Constitutional Convention, understanding of the doctrine in question by the constitutions of several states in existence at the time of the United States Constitution was adopted, the understanding of the United States Constitution by the United States Congress, the opinions of the first Chief Justice of the United States Supreme Court, the background understanding of the doctrine in question under the English Constitution at the time, the statements of support for natural law and natural rights by the framers and philosophers referenced by them, the opinions and statements expressed in Federalist Papers correspond with other states about other federal action determined in the opinion of the legislature to be unconstitutional with the goal of a coordinating response between the states. On page 7, on triple I is one of the places where we had another correction. It says individually, we would reaffirm the oath of office. We don't want it to be a reaffirmation. We want it to read as swear or affirm, and it's a new oath. That's why we don't want to reaffirm the oath that we took. But I'll read the oath to you. It says, I do solemnly swear or affirm that I will support, obey, and defend the Constitution of the United States and the Constitution of the State of Wyoming, recognizing that both constitutions are contracts and must be upheld based upon the understanding of the parties at the time of their ratification or adoption, and that I will fulfill the duties of the Joint Standing Committee on Federalism with fidelity and free from purposes of evasion. And so I just want to make sure that you understand that that's why it is being changed to swear or affirm, is because it is a new oath. It sets the time that we'll meet. This committee would meet not less than one time per week during the legislature. Goes through and talks about that these will be public meetings, just like this committee does, and that it would also be staffed by LSO. The last thing it does is it goes through the scope and review, talks about how the committee shall report to and advise the legislature the following: the constitutionality of federal mandates, legal questions, and policy issues surrounding state and local government rights under RS 2477, legal issues relating to school trust lands, its beneficiaries, and attendant rights of the state, advisability, feasibility, estimated costs, and likelihood of the success of challenging any federal enactment the committee determines to be unconstitutional. And then federal court rulings that hinder the management of the state prison systems or place an additional financial burden on states' finances, diminish a right reserved to the state or its citizens by the United States Constitution, including and especially Amendments 9 and 10, expanding existing power or grant new powers to the United States government beyond the limited enumerated powers provided in the United States Constitution. We'll look at federal law, rules, regulations that adversely affect water, property rights, the rights to interests of the state and local governments, including sovereignty interests and the power to provide for the health, safety, and welfare and promote the prosperity of the state's inhabitants. And then under 7, it says conflicting, duplicative, or cumbersome federal regulations or policies related to the management of federal lands in the state. In reviewing actions under this paragraph, the committee shall also receive draft environmental impact statements and assessments for any federal proposed land management. Then 8 is federal intervention that would damage the state's mining, timber, tourism, ranching industry. 9 is the authority of the Environmental Protection Agency to mandate local air. And then we had another amendment. We had end water quality standards and penalties. That was omitted. So we wanted to, that's covered with the standing committee amendment. Number 10 is federal agency law enforcement within the state. Number 11 is the possible loss of federal funds to the state or the counties if the federal action is determined in the opinion of the legislature to be unconstitutional. Number 12 is entries in the federal registry, which may impact the government of Wyoming or its residents. And then number 13 is any other federal enactment likely to have adverse impacts on the state. And then the subsection B is another one where we had some language changes. It should read, if the committee by a majority vote, And then we would recommend that you strike of all members present from each house voting separately. And then you continue on with determines that in the opinion of, and strike the legislature and just put the committee, that if federal action is unconstitutional action, the committee shall report the determination to the Senate and the House of Representatives. So you'd report back to the body. And then C, subsection C takes that on from the legislature, making that determination, presenting that to the governor once the body's approved it, and letting him have a chance to review it again. And then there's two more sections which deal with the coordination of how the Secretary of State would send notification to Congress. And then the last one is 2811-805, which is the authority preserved actions to be declared unconstitutional. This act shall not be construed to limit or alter the powers that are already there for determining that. So if the federal action is determined in the opinion of the legislature to be unconstitutional action, it shall have no legal effect in this state and shall not be recognized. So we have the ability to tell them we're not going to follow that. Neither the state nor political subdivisions of the state shall spend any money on those items that we've declared to be unconstitutional. It provides a provision in here where a public officer authorized to enforce the laws who's taken an oath to defend both the U.S. and the state constitution. It affords some protection to them if they choose not to enforce that federal action. And then this act does not prohibit a public officer who's taken an oath to defend the United States Constitution from interposing or stopping the action of that federal government, which in the officer's best understanding and judgment violates the Constitution. So it provides protection for local officers. Then Wyoming officials in federal, state, and local government shall honor their oaths to support, obey, and defend the United States Constitution and shall act in accordance with the Constitution at all times. And then lastly, 2811-806 is the authority of the Attorney General. And it sets it up where the Attorney General can sue to defend the state and in an action to prevent the implementation and enforcement of any federal action that this body is determined is, in their opinion, unconstitutional. The Attorney General may initiate proceedings against a person who attempts to implement or enforce federal action determined in the opinion of the legislature to be unconstitutional. And then the Attorney General may appear before a grand jury in connection with an offense that the Attorney General is authorized to prosecute. And then the last is the authority to initiate proceedings prescribed in this section does not affect the authority derived from other law. So it's not circumvent any of that. And then the last is when it becomes effective. And there is a fiscal note that you'll see. They're saying that they're expecting nothing in 2022. In 2023, there's 26,700. In 2024, there's 44,500. And that is just what they anticipate for the salary per diem and the stuff that it would cost to add this standing committee. So with that, you can see it's a rather extensive bill. We spent a lot of time on it. And I know that you've had emails. I know that we knew we were going to be up against the time constraint. I know that there's been a bunch of emails sent to you. I hope you've had a chance to read some of those. I would say that I'm asking Mr. Chairman, would I move the standing committee amendment, or is that something you guys do? Or
I think we have to do that.
okay, and that's what I wasn't sure. But you have it. It's been handed out. So I would be willing to answer any questions that the committee may have. And I know you guys, former Representative Marty Halverson, I know she was going to be online. She is one of the authors of this document. This is obviously not a document that Bob Wharf drafted by himself. So she may need to help. And I don't know if you'd want to bring her in and let her provide some testimony.
We will.
Before we ask questions, or if you want to, she may need to help answer some questions.
Okay. If you want to, if you get some questions, you want to refer to her, that's just fine.
Okay. With that, that's the bill, and it's a mouthful, But it really is. You look at what's going on today. This is the second administration that I've seen where we've seen actions that have directly impacted this state's ability to maintain its economies. And so this is really an effort and an attempt to really start pushing federalism once again. It's a common term that we used to talk about a lot more. We don't talk about it nearly enough, in my opinion, but this is setting up a process where the state would now be taking an active role, looking at the executive orders, any of the actions that are taking place on a federal level, setting up a process where they can all be reviewed and we can take action if we think that they are outside their scope of authority. So that's, in layman's terms, that's how I understand what we're trying to achieve. It does set up this standing committee. And so with that, any questions that the committee may have.
Thank you, Mr. Wharf. Representative Blackburn.
Thank you, Mr. Chairman. Representative Wharf, I've got a lot of questions. I'll try to get by with just 3. Page 4, where you decided that 6 members from the Senate and 6 from the House. How did that number come about instead of 5 and 9? Or
And Mr. Chairman, that's just the numbers we came up, and I'm assuming they're trying to maintain a balance between both those chambers. But I don't really have an issue to either one of that. To me,
thank you, Representative.
So I don't have a good answer. Maybe Marty can answer that when she comes on.
So page 7, where you have a new sworn oath, why did you see fit to have a different type of an oath? I'm just wondering where that came from and how.
Mr. Chairman, I believe this was taken from, we talked to multiple states that have been working on this similar process. And I believe that this is an oath. I don't know which state it was taken from, but it is an oath that we felt like it reestablishes the importance and the focus of federalism, and that we are focusing back on the original Constitution and the state constitution. So it is a different oath than the oath that we all take, but that was something that they wanted this committee to understand what they're doing. And this is, to me, the affirmation that this is a big deal. We're actually going to be challenging the federal government on things that we think they are acting without authority.
Thank you, Representative.
Any follow-up? Representative Blackburn? Any other questions? Representative McGuire.
Thank you, Mr. Vice Chair. So I do have a very basic question. And that is, you mentioned we, and you mentioned the Republican Party. And then, of course, we have an email that was presented to us that's signed by Scott Brown as a member of the Wyoming Republican Party. And I'm just curious, was this brought during state convention? Was this brought to the body? And was the body allowed to give feedback and to vote on this?
Mr. Chairman, the subcommittee was set up, I think it was a little over a year ago, but this document was not, the last state convention we had, this document was not finalized at that time, so it was not presented to the committee. The subcommittee, when it completed the document, it was presented. I don't know if it went before the central committee, because that was something that Marty and Scott handled. So that's the best. Like I said, Marty and Scott could probably answer that question better than I can.
Any follow-up, Representative?
So you're representing that this is a document from the state party, but the state party never approved it.
I can't answer that. I can tell you that this was a subcommittee that was put together by the party, and it represented over 19 different counties that were actually participating in it. As far as, I don't have any involvement in the central committee or anything, so I don't know. That's something that Marty can probably address better than I can, because she, and I don't know if Scott's on the central committee, but I do know that the chairman of the party has seen the bill, but I can't attest as to whether or not it was ever ratified. I just know that the committee, when they had a final document, that was presented to the chairman.
Mr. Speaker, Maybe we should just ask Marty.
Well, I
Might be-
want to get any questions from the legislative body before we go to public testimony. Yes, Representative McGuire.
Thank you, Mr. Vice
Another
Chair.
follow-up.
So I'm curious if this is being brought forward by a partisan party. Does the Wyoming statutes, do they have a provision where a partisan party is able to present legislation and lobby for that legislation? Or does this take it into the position of having been brought by a lobbying group?
Mr. Chairman, if I can answer
Yes.
that, I'm neither a lobbyist, nor am I presenting this as a document from the party. What I explained was the process whereby this document was put together. So if that's been misconstrued, I'm not saying this is the GOP sent me here to get this done. A subcommittee was put together that generated this document, and I'm presenting that document. And that may get into the legal issues. I don't know if the party can do that. I'm not an attorney. All I can tell you is that there was a subcommittee that was put together by the party. We worked on this for a little over a year, and this is the result of that document that the subcommittee put together. But I'm not here. The chairman didn't send me here. I'm not lobbying. I'm not presenting this bill for the party. I am a representative from my district, and I'm bringing this bill because I do think that Wyoming is sovereign. And with all the things going on, I think we need to have a process where we can challenge the federal government in any opportunity or any time that they've operated outside their scope of authority. So I don't know if that answers your question, but I want to make it absolutely clear. I'm not a lobbyist. I'm a legislator just like you are. I'm presenting a bill. This has, the genesis may have been from members of the party, but the party, as far as I know, hasn't sanctioned this bill.
I'd like to bring a point of order, Mr. Vice Chair. I think that this should be tabled. I think that we should have an opinion from LSO as to the appropriateness of even hearing this bill.
On what basis, if I can ask?
On the basis that A, you represented that it has come from a partisan party, and through the actions of your presenting it, it is turning you into a lobbyist. And I think that we have an issue here. So
Please work through the chair.
oh, I'm sorry.
Yep,
Mr. Chair.
I'm sorry too,
Apologies.
Mr. Chair.
That was my apologies.
Yeah. I'll take that point of order under advisement, but I think we're in the middle of testimony and we might as well finish any further questions. Representative Duncan, I think had a question. And Representative Clifford.
Thank you, Mr. Vice Chair. I have several questions. They're kind of random, bouncing all over, so you might want to take notes. They're a little schizophrenic, so they're going to be bouncing all over. One, so if you'll indulge me, Mr. Vice Chair, if I ask all of them so that he can answer them all. One, the Constitution, do you believe it's a living document or historic reference? Two, do you believe in growth of government? Because that's basically what this is. We're creating another committee. We're growing government. Three, who's going to be the expertise of these appointees? Because basically we're asking what's constitutional, what's not unconstitutional. How do we currently find something that's unconstitutional? So how's that expertise going to be? And then four, who's going to, if I were to be on this committee, or if I'm a legislator who's a part of judging these bills that come through, or if I'm on this committee, who's going to be judging my support, which is kind of going towards a follow-up with my colleague here. Who's judging my support? Because the current party already is in, I'm already under a microscope of whether I support or don't support under extreme microscope, as far as very narrowly defined of what's approved and what's not approved, as far as the majority party as a Republican. So
I think that those are enough to remember at one time.
so that was my last question.
I did write them down, Mr. Chair, and I'll do the best I can.
Yeah, that was my last
Uh,
question.
And you asked whether I believe the Constitution is a living document or historic document. That's one reason why this makes it very clear that the Committee on Federalism is to look at the original Constitution and the basis for the formation of that, and look at the historic time frame when all that was drafted. So in answer to that, I would say that it's my opinion that we are determining that it's not a living document, that we are saying that the Constitution is the Constitution, and that the enumerated powers that the federal government was given at the time of the signing of the Constitution remain the same, that those powers have not changed, and that the powers reserved to the states remains the same. Anything that's not been delegated to the federal government are powers that are vested in the state. And keep in mind, Mr. Chairman, that is the purpose of this committee, is to push back against all the federal intrusion into state powers and authorities. That's what federalism is. So the next question is, does it grow government? It does grow government in the fact that you have another standing committee, but we're not electing any more legislators. Somebody's going to have, I know there's several freshmen that this year only got assigned one committee. If we had another committee, there's probably enough that we could all be on two committees. So it is growing government, but I guess I'm going to ask the question back. Is it not important, if you believe the state is sovereign, that we protect that sovereignty, even if that requires us to establish another committee? The next question you asked is, who is providing the expertise? I think it's us. I mean, we're the duly elected officials, and it's up to us to look at the enumerated powers. I think the Constitution was written very clearly, and I think it's up to us to determine whether or not we feel that they are exercising outside their scope and authority. And if it's not the state elected officials that do that, I don't know who else that would be. So to me, that's kind of what we do all the time. We sit and look at different bills. We're modifying laws, we're changing them all the time. And I think some of the problems that I see is we've had a tendency in the past, when we have opinions issued by the Supreme Court, they're called an opinion. And because Congress, in my mind, has not been very effective, rather than addressing some of those issues that the Supreme Court has addressed, because if Congress was to pick up the issue and pass legislation to either clarify or correct the interpretation that the Supreme Court issued, to me, that's the process. Just the opinion is their opinion. It doesn't create new law. And so if the majority of the people in our country think the opinion was wrong, Congress should have the ability to to draft legislation that corrects that interpretation. And I don't know if that's getting off into the weeds too far, but then you asked the last question, who's going to review it? It's set up to where the committee, the Committee on Federalism would look at environmental impact statements, executive orders, environmental assessments, any action that's brought to their attention, they could review. If they determine that there is an action that has occurred that was outside the scope and authority, they would bring that issue before the entire body, both the Senate and the House. They would have that discussion, and both bodies would determine whether or not it moved forward. If there was agreement, it would move forward to the governor. The governor would get an opportunity to review it. The governor, if he is comfortable with it, then it goes on to the Attorney General. And now we're starting into the legal process as far as notifying Congress and how the state's going to respond to that. So I hope that answers your question.
I had Representative Clifford next, and then I'll get to you.
Thank you, Mr.
Representative
Chairman.
Clifford.
Representative Worth, trying to wrap my head around this on page 3, Romanet 2 there at the top of the page, line 1 through 3, shall rely on the plain meaning of the text of the United States constitutional doctrine as understood by the framers of the Constitution. So my concern as a member of a sovereign tribe, the treaty clause is part of Article 2, Section 2, Clause 2. Where does that fit? And could you provide a definition as plain meaning of that text? Does it include the treaties that are in the Constitution with tribal nations?
Representative Warren.
Mr. Chairman, Representative Clifford, I appreciate the question, and all I can say is I do think it's important that we follow the Constitution as it was originally written. And I recognize the sovereignty of your nation, and I think we need to recognize the sovereignty of the state of Wyoming. And I do think, I hope I'm not offensive to you, but I think there's been times when our government has not treated your nation fairly. And I do think that you guys have done a much better job fighting for your sovereignty. There's been periods of time when I think the tribal nations have done better, and there's times when they've not done very good defending their sovereignty. And I think this is just trying to set it up to where Wyoming can fight for our sovereignty, just as the tribal nations have fought for theirs. So I don't see this as diminishing this. I think it strengthens the position of the tribes. You have agreements that have been made with our government, and I think our government should honor those agreements just as much as they've honored our agreements as a sovereign state. So I think that gets to some of the problem. I think when you read the Constitution, it's plain. I don't think you need an attorney to read it and interpret what it says. And that's what I think we're trying to get at, is that it's the plain reading of that, not how it's been construed and twisted around to mean so many different things. But I don't know if that answers your question.
Thank you. Representative Hunt.
Thank you, Mr. Vice Chairman. Representative Wolf, is this, as I read this bill, that, I mean, hypothetically, this committee sounds like it would be a body unlike any we currently have in this legislature. And so you're talking about that it would go through this process of review and recommend on federal laws, federal actions, executive orders, so on and so forth. I guess, would it actually, upon finding something that it deems to be in violation of the state's sovereignty, would it propose legislation to address that, or would it just be some other form of an airing of grievances on the floor? Because I and maybe I miss it, I don't see anywhere in the bill where it specifically says that the committee would bring legislation forward after its review process has been done. And so my concern is that if that's not, and maybe that's the case, but if that's not the case, that this isn't just creating a new committee, it is fundamentally changing what we do as a legislature in its current form and in its current process. And so can you kind of help explain that, please?
Well, and Mr. Chairman, Representative Hunt, it's my understanding that this committee would act no different than any other committee. If they want to bring a bill forward, they would bring a bill forward and they would discuss it just like Corporations Committee would. But it's really, their main focus is going to be looking at federal actions and determining, I'm assuming like when you get a bunch of executive orders, be reviewing those and looking at how the state should position itself to address those executive orders or any EISs or EAs that have been issued in the state. But I think it still comes down to this committee would make recommendations. If they thought it required legislation, they would take it back to the body. And if the body agreed that that's the direction they should go, then I would assume that the committee would draft legislation that would bring a bill that would go through just like any other committee bill. If it was their determination that they wanted to say that's an illegal act, we want to tell everybody to disregard that. It's outside their scope of authority, that it would be up to the governor to look at that. If the body agreed, then it would go to the governor and then it would go to the attorney general and we would probably take legal action, I'm assuming. I don't think that that, we could do things without having legal action in the courts. But that, to me, it's still up to I don't see it functioning any different than our current committees would. If it requires a bill, they would bring a bill for it. If it didn't, it might be bringing a recommendation to the executive branch to have the Attorney General take legal action. Yeah.
Okay, thank you, Mr. Vice Chairman. I guess, okay, to that point, the governor, the attorney general and the governor, if they wish, they can currently sue the federal government if they see something unseemly. I think that the way that our body operates as a citizen legislature, where we're only in session not more than a couple months out of the year at most. I guess my point is that that's all well and good if we're putting forward legislation or recommendations that says, yes, that the executive should sue the federal government for X, Y, and Z, but they can do that much more rapidly of their own accord if they see fit, whether we're in session or not. And I mean, depending on who's in office, that seems to go more quickly or more slowly, but I can see that would slow the process down of being responsive to federal action versus what the current process is.
Do you care to comment?
Well,
Representative
Mr.
Wharf?
Chairman, I would say it gives us another tool to use, in my opinion. Besides just counting on the executive branch to take action, it would give the legislative branch the opportunity to make recommendations that they take action on specific things. So I see it being additive. I don't think it subtracts anything from what the current process is, but it would allow a layer for the legislative branch to be looking and to be delving more deeply into some of this stuff. I would imagine that the executive branch has got lots of irons in the fire, and they may not have the opportunity to cover all the things that a standing committee would. So,
any other questions for Representative Wharf? I actually have a couple.
be nice.
Well,
no,
I'm
give
just
you that,
Mr.
Mr.
Seeking
Chairman.
for understanding here. You have standing committees set up in statute, and I tried to look in the statute and see where our standing committees were in statute that we have now, and I didn't see any there.
Mr. Chairman, you bring up an interesting point, because that's one of the questions that when I visited with the LSO attorney, she couldn't answer that question either. And so I just told her, I said, I don't know the process. She didn't know the process, so we put it in the bill. And I just said, the only way I could answer that is I believe that there's 60 members in our chamber. And if the 60 members in our chamber pass this bill and say they want to create another standing committee, that whether we followed the right process or not, there's another standing committee. Now, I won't purport to, I can't answer something that the LSO attorney didn't know. And so that's the best answer I can give you. That's the answer I gave her when that was brought up. And she just said, point taken. I mean, so that's the best answer I can give you.
Okay. Another question, and this is just in general. I've got to believe there are literally hundreds, probably thousands of court actions determining whether certain actions have been unconstitutional or not. And there are legal scholars that have studied, the greatest legal minds in our country have studied this issue. And you expect 6 lay people in the legislature to be able to determine the constitutionality of all these things. On page 11, you talk about any federal or any federal register impacts on the government of Wyoming or its residents. I mean, that's a full-time job right there, just keeping track with what Federal Register says. How do you expect us to accomplish this?
Well, Mr. Chairman, I mean, that's a hard question. I guess to me, what you're asking is how do you eat the elephant in the room? And I can tell you all you can do is eat it one bite at a time. But I think it still comes back to the problem we have. I think for far too long, the federal government has been expanding and encroaching on states' rights. And that's what this is. This is designed to set up a mechanism, and what we are hopeful, and we mentioned that we'd like to see this in other states. And that's really a concerted effort to try to get all the states at some point to start doing the similar thing. But that is one of our problems. It's too easy for us to say it's too big a thing, we can't take it on. And I'm going to tell you, I doubt, Mr. Chairman, that this is perfect. But it's a concept, it's a start. And I have the confidence. I mean, I obviously am just like every one of you. I made a conscious decision to throw my name in the hat, and I'm here trying to do the best I can for the state. And I think we're all here in that same boat. We have LSO attorneys that are there to provide assistance and guidance. But I do question, where do you start? And I look at, I mentioned it before. This is the second administration that I've seen, to me, that's made a personal assault on our state and basically destroyed our economy. And we barely were starting to get back from the last one. And I'm hopeful that we can survive what we are enduring now. You see all the onslaught of things coming. I mean, if you've been looking at what's coming down the pipe in Congress, our Second Amendment, our First Amendment, I mean, those are just the things that are kind of under threat right now. And that doesn't talk about all the other things, but I do think it is an overwhelming, almost Herculean task that's before us. But if this state doesn't start standing up, and to me, I think Wyoming's always led. And I think that's the whole purpose, is I want Wyoming to be out there leading on this. I think we can get other states. I know Utah, Idaho, Montana. I know those states have been working on it. I think North Dakota, Marty will be able to tell you better, but I know there's been a consortium of states that have been working on a similar fashion, trying to establish a process where we can have an organized, concerted effort to push back. So.
Thank you, Representative Wharf. I think I'm going to defer to my more experienced chairman to take over, if you wouldn't mind now.
Sure. Anybody else have questions? Sorry, I had a very enjoyable education battle that I lost 4-5 just now. Yeah, nobody likes school districts consolidations. Other questions, Representative Wharf? I think because it was a publicly noticed bill and we are taking public comment, when the time comes to move action on the bill, I would take that. So is there anyone that's here for public comment? Representative Wharf.
Mr. Chairman, if I may, you weren't here. Marty Halverson, former legislator, had helped draft this document. I know she's online, and that's one thing I said is when I presented is that, she can probably answer some of the questions that were asked that I couldn't answer. Okay. And so I would ask maybe that you give her that opportunity. And
sure.
Do you want me to sit here? Do you want me to?
Right there's fine.
Okay.
Hi, Representative Halverson, former representative. Good to see you. The floor is yours.
Thank you so much, Chairman Zwanitzer. First of all, I want to address Representative McGuire's concern. This bill came from a committee formed by the Wyoming Republican Party. When we developed this bill, we purposely did not run it through the Wyoming Republican Party, just so that we can sit here and tell you this is not a product of the Wyoming Republican Party. This committee was given total autonomy, and we did a lot of work over a year, and this is not a product of the Wyoming Republican Party. Secondly, I really do want to address Representative Clifford's concerns, and I would refer her to the original Constitution, Article 6. The laws of the United States, which shall be made in pursuance of the Constitution, all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land. So I think it's safe to say that the treaties with the sovereign nations will not be impacted at all. And there was a question about the oaths. If you all notice, the county assessors take their own oath, which is different from the oath you take there in the legislature. So we saw this as perfectly consistent with the varied oaths that varied elected officials take around the state. House Bill 256 represents the hard work of a lot of people. As I said, 19 counties, your own counties, Goshen, Weston, Platte, Uinta, Fremont, and others. It is our request and our hope that you pass this work out of your committee and put it to the House floor for the larger debate that we think it deserves. It is, and going to another point, it is our belief that this country has become more reliant on case law than constitutional law. Heaven knows our courts have gotten it wrong in the past, including the most supreme of our courts. And now is the time to begin an in-depth review of Wyoming's relationship with the federal government. As Justice Samuel Alito said, states are sovereign. It's time they acted like it. I think I captured most of the questions. Representative Duncan asked about growing government. I think it grows representation, not government. Nothing is expanded except the legislature's oversight. Are there any questions?
Hey, committee, any questions? Representative Halverson, Representative McGuire, go ahead.
Thank you, Mr. Chairman. So you mentioned that this is the product of the work of 19 counties. As a member of the Natrona County Republican Executive Committee, I certainly don't remember ever seeing anything like this. Was Natrona County and probably Laramie County, were they specifically excluded from the creation of this bill?
Mr. Chairman?
Ms. Halverson, if you know.
Thank you, I do know. We solicited memberships. We tried to get them from all 23 counties. Unfortunately, Natrona County and Laramie County representatives at the State Central Committee declined to participate.
Okay, further questions, Ms. Halverson? Not seeing any. Do you have a question? No? I just want to get through public comment in the next 6 minutes. Mr. Sick, anybody here in the audience to testify in the bill? I see a couple of you with the party. Nope. Is there anyone else? I don't have my computer. Is it Danielle or Clarissa right now?
It's Danielle, Mr. Chairman. We have 1, 2, 3, 4, 5 people waiting to testify on this bill in the waiting room.
Mr. Ferguson, is he one of them? I think we'll
Yes,
try to
Mr.
get me.
Chairman, he's the first one.
All right, if you throw him in, I hate to pick. Maybe you can throw them all in and we can each do 1 minute.
Sure, we have Mr. Ferguson, Mr. Bendel, Mr. Moline, Scott Brown, and Eldon Stahl.
All right, we'll just throw them all in, put all their cameras on and see what interesting things they can bring to the debate. I'm waiting for one of their cameras to appear. Whoever shows up first, I'll call on you. Mr. Moline.
Yes.
Welcome, Brett. The floor is yours.
Thank you, Mr. Chairman. I probably had a little bit more practice hitting these dang buttons than some of the other people. Brett Moline, Wyoming Farm Bureau Federation, sitting in support of this bill. This fits with my members' policy to push back on what the federal government is doing, perhaps doing some auditing to make sure that they are not overstepping their bounds. So I really appreciate the concept. I don't know if this is the right vehicle or not. I do have the concerns that it will be cumbersome and slow, but I do like the idea of the legislature having a voice to fight back against what the federal government is doing to its citizens and its resources. And with that, Mr. Chairman, trying to be as brief as possible, I'll sit for any questions.
I appreciate you, Mr. Moline. Any questions for the Farm Bureau? Seeing none. Mr. Brown, welcome to corporations. You have about 1 minute. Floor is yours.
Thank you. Can you hear me?
Certainly can.
Okay. I appreciate the opportunity to testify. I'd first like to respond to Representative Ayers, one of his questions. Each one of you, everyone in the legislature has taken an oath to let's see, exactly your oath. To support, protect, and obey the Constitution. And this is a vehicle that actually will give you a means whereby that oath can be fulfilled. The question was asked, with all the courts and all the case law and everything that's been done on this, how can we as legislators, part-time, that just do this for 2 months a year, how can we do this? Well, I'll tell you, this is your responsibility. You are the ones we elected, and it's the legislature that has the power to push back against the federal government. Don't wait for the governor's office to do it. It's a legislature's responsibility.
And Mr. Brown, I'm sorry, I got to cut you off unless there are questions. I came in late to the game, so I don't know what happened, but in the efficiency of time, any questions, Mr. Brown? Seeing none, certainly appreciate your commentary today. Mr. Ferguson, you have 1 minute.
Yes, thank you, Mr. Chairman, members of the committee. You all have my testimony, so you can read that at your leisure. I would just point out that one of the biggest problems in state sovereignty is that states have not taken the opportunity to challenge the federal government's overreach on enumerated powers. We've had courts and Congress many times really take certain clauses out of context in the Constitution, those particularly being the necessary and proper clause, Article 1, Section 8, Clause 18, and the Commerce Clause of Article 1, Section 8, Clause 3. If I could just restate part of the necessary and proper clause, Congress shall make all laws shall be necessary and proper for carrying into execution the foregoing powers and all other powers that are vested by this Constitution. It was the last enumerated power. And if you follow what I put in my testimony that I sent to you, you'll see that even the Federalists during the Constitutional Convention specifically said that this does not give the federal government the power to make any and all laws which they deem to be necessary and proper. In particular, James Madison says this clause only enabled them to carry the execution of powers given to them, but gives them no additional power.
Federal 6. Sorry, Mr. Ferguson, I got to cut you off. I couldn't agree with you more. And that's probably why they call it the elastic clause, because it just keeps expanding. Any questions for Mr. Ferguson? Seeing none, thank you very much. Mr. Bendel, welcome to Corporations. Floor is yours.
Yeah, can you hear me?
Yes.
Okay, great. So I had a couple points, and I'll leave my personal experience for your review because I submitted a letter, so you can read all about that. But I also wanted to comment on the concept of between a living document and a historical reference. And there seems to be some confusion and people conflict on this. When I was on the committee, and so I know when we say original intent, that doesn't mean we want to go to the original Constitution and re-implement slavery. What it means is that we want to interpret the Constitution as it was written when the Constitution and that particular part was written. So for instance, 250 years ago, women couldn't vote. Okay, now we've passed the 19th Amendment and women can vote. So what's the original intent of the 19th Amendment? As written, when it was written, women can vote. So people need to, when they hear, oh my God, we want original intent, that doesn't mean we go all the way back 250 years and start oppressing people. What it means is if we passed an amendment yesterday, what was the original intent yesterday? And so, just to clarify that. And so there's no attempts to repress anyone or go anything like this.
All right, I appreciate it, Mr. Bendel. Sorry, I got to cut you off.
Sure.
John Locke's second treatise on government is amazing. And I'm all with you on that. Any questions? Seeing none, Mr. Stahl, welcome to Corporations. Floor is yours.
Can you hear me?
Yep.
Okay, just a couple points. So we did have somebody say that, how can the legislature deal with these weighty issues and how they're going to have time for it and all this? One thing it's good to remember is that 35 out of the 55 people that signed the original Constitution back in 1787 had a legal background. That means, and actually not all of them were practicing lawyers. That means that at least 20 of them were lay people like you and me. The beginning of the Constitution says we, the people, And in reality, it was representatives from state governments generally that went to the 1787 convention and signed the Constitution. But it was something that was understood by lay people. They actually drafted it, and it was actually the states that ratified it. So it was created by the states. Later, Madison pointed out in Federalist 44 that the state officers have an essential agency in giving effect to the US Constitution. So this is a duty that they have. Madison pointed to various ways, such as what today we would call anti-commandeering. It's been recognized by many lawyers, including twice in the Supreme Court, that the state employees, we can disagree, of course, on whether something is constitutional or not, but what we should not disagree on is that state employees work for the state. And if the state says, you know, that's not your job to do that, whatever it is to implement some federal action, that's not their job.
All
That's
right.
okay.
Thank you, Mr. Stahl. Sorry to cut you off. We have 15
problem. That was
minutes
it.
apparently on an education bill. Questions for Mr. Stahl? The brilliant thing about the Constitution is they didn't leave it up to legislators. They put it right out to the people to ratify in each state. Go Delaware. All right, seeing any other further public comment? Seeing none, we're going to close public comment committee. What is your pleasure on House Bill 256? Was there a motion at all? Or anyone want to move 256?
Well, I just got a comment. It's way too big of an issue to get squeezed in this length of time. It's bigger than that. And so we can't do anything about it right now.
That was not a motion to bill. Anyone else wish to move the bill? Going once, going twice. All right, we will hold the bill in committee for lack of a motion. Sadly, Representative Sweeney, we are not for the 5th time getting to your bill, but I know you're all, the rest of you are here for Representative Sweeney's bill. Don't worry, it'll be an interim study. And we might take up this issue in the interim as well, Representative Wharf, because it is near and dear to my heart. Thank you very much. Even though I missed most of your testimony, I'll go back and watch it. Thank you. In committee, 15 amendments on the education bill. I'm sure you want to get up there as quick as possible. And I will have the list out for Monday as soon as Barb and I get acquainted.